Meeting of the St. Louis County Board of Zoning Adjustment to order. The board members present today are Angelia Bills, Chair, and Justin Randall, Vice Chair. The Department of Planning staff members are Debbie Nesbitt, Mel Wilson, Abby Freudel, Ashra Mrikra Mathalaka, Shane Stryler, Kayla Holland, and Gretchen Arnold. Also on the call is John Burford from the County Counselor's Office. First, I offered into the record the affidavit of publication pertaining to today's meeting, May 31st, 2023. The board hereby takes official notice of and admits into evidence on the record the St. Louis County Zoning Ordinance, Chapter 1003, the St. Louis County Revised Ordinance 1974 as amended, and Chapter 1004, St. Louis County Revised Ordinance 1974 as amended. Next, I would like to call for a motion to approve the minutes of the previous BZA meeting of May 17, 2023.
Excuse me, I'll second that.
I move and Justin seconds. All those in favor? Aye.
Aye.
It carries. This meeting is conducted as a teleconference and is recorded. The planning staff will read each request into the record and present technical advice to the board if needed. The petitioner will be unmuted, state their name, and make a brief presentation to the board explaining the reason and hardship for the requested variance. The board will not consider financial hardships. Board members may ask questions to clarify the facts. When the board is satisfied with the material presented, the chairperson will then ask if there is anyone in favor or opposition to the request. To do so, click the hand next to your name. If any comments were submitted, staff will read them into the record. Before a call for the vote, the petitioner may request a continuance in order to bring in additional documentation. The board may also request a continuance to gather additional information or for a visit to the site. Once comments have been heard, the chairperson will call for a vote. At that time, the discussion is ended. No further discussion is permitted. The board will generally make a decision today. Since there are only 2 members present at this time, if the board's vote is split, the request will be continued to the next regularly scheduled meeting when the 3rd member is available to vote. If a variance is approved, the petitioner has 6 months to obtain the necessary permits or establish the use requested, or the variance will expire. Petitioner or any interested party has the right of appeal to the St. Louis County Circuit Court. Paperwork indicating the board's decision will be mailed to the petitioners.
So there are 2 requests or 2 petitions on the agenda, and one is a little more involved than the other. So if the chair and the other member are willing, we can present the second request first, since it's a little more straightforward, or we can do 32 first, but I wanted to give that option to the board.
We can go with the first, with your recommendation.
Okay, so okay, we'll start with 3323, Abby.
Okay.
Thank you.
3323 Durrell Harley requests an exception to the side yard regulations for the purpose of maintaining a carport at 12116 Krenning Lane, maintaining a side yard of 1 foot in lieu of 10 feet as required by the R2 Residence District regulations of the St. Louis County Zoning Ordinance. Mr. Harley, you should be able to unmute your, give me 1 second. Mr. Harley, I believe you should be unmuted to give your presentation.
Is he calling user 2?
Yes, and when I click unmute, it says request sent.
What if you make him an attendee again?
Yeah, that's what I was gonna.
Oh, he's unmuted.
Hello.
Okay, we can hear you now.
Okay, I was like say put in this request because I was unfamiliar with the process. First of all, when I had built this carport, and I think it I was asking for an exception because it was offset by, I think, 5 feet, 6 inches, compared to the 10 feet side yard.
Okay. Have you already constructed the carport?
Yes, I had. And then, excuse me, one of the people was out inspecting someone else's yard for a complaint, and saw that I had constructed it, and said that I needed a permit, and I had to go through the process.
Okay. And what was the reason for the hardship for your variance?
It wasn't necessarily a hardship. When I had spoken to the person from Public Works, they said I had to put in an exception. And then I had to attend this meeting to see if I was approved for my exception.
So the hardship is why the carport can't be located 10 feet from the property line, which is the zoning ordinance
Okay.
requirement. So that's what the chair is asking, is why you need the 1 foot in lieu of the 10 feet from the property line.
Well, I guess I'm trying to really try to understand and wrap my head around what you're asking.
So why do you need the adjustment to the zoning? So was there another way you could have put the carport where it wouldn't have, went past the ordinance?
At the time now, since it's built, it'll be a hardship because I actually have to pretty much take the entire thing apart
Mhm.
for that the last 4 feet, 6 inches. For that offset.
If I can help him out a little bit.
Thanks, Deb.
The posts are in the ground.
The carport is next to the attached garage. So
Yes,
he
yes,
will be
ma'am.
having a paved driveway to this carport. And it's his house sits on the property a little bit of an angle. So it's the back corner that's what is the closest part. I mean, the front still doesn't meet the setback, but the closest point is the rear of the carport.
Yes, I see that.
So, yeah, his
It
shape
seems
of his
like
lot's very difficult.
Okay. Yes, I can see that he does have a narrow shaped lot. So that
Mhm.
hardship is the narrow shape of the lot.
Yeah, like a pie almost. Yeah. Okay.
Justin, did you have any more questions?
I did hear, I believe Debbie mentioned that he is going to do the asphalt piece, so there's not a variance to that, correct?
Correct.
Just the side setback.
Is there anyone here in favor or opposition?
I do not see any hands. So at this time, I will also mute Mr. Harley so the board can take their vote.
33-23, I vote to approve the variance as advertised and the hardship just being the odd shape of the lot.
I think that's fair. I'll second that motion. Staff the only question I have, I mean, is there anything regarding like a condition that you want that the asphalt driveway be done, or is that?
He would have to do the pavement.
Okay,
If he
so,
didn't pave it, he'd have to come back to the board to ask
Okay.
to use a different material
okay,
because of the zoning district.
perfect. Then I second the motion as it was stated.
Okay, all those in favor? Aye.
Aye.
Okay. And against it passes.
32-23, Mark and Laura Rafe requests an exception to the side and rear yard regulations and the off-street parking and loading regulations at 13281 Spindle Lane, maintaining a side yard of 1 foot in lieu of 20 feet and a rear yard of 4 feet in lieu of 20 feet for an 8-foot 4-inch fence, and allow the continuance of non-dustproof gravel rock in lieu of a paved area as required by the NU non-urban district regulations and section 1003.165 off-street parking and loading regulations of the St. Louis County Zoning Ordinance.
So we did prepare the staff report that was forwarded for this this request. Here you can see the aerial with the site outlined in red. This aerial shows the residents on the site. This aerial does not show the detached garage, but it does exist on site just to the east along the eastern property line. Next, I think, is the preliminary plan that goes with this request. So you can see the home there in the center of the site, the garage along the eastern portion, and then the two aspects at play for this request are the fence noted in the red line along the eastern and northern property lines, and then the gravel surface in the yellow area. So the site photos here kind of go counterclockwise around the site. There are two materials on site right now along the drive aisles. This darker material you see here, this is the drive, the existing driveway out to Spindle Lane. This darker material is a trap rock and meets the dustproofing method required by county transportation. So that material is fine. This image going north showing the eastern property line, this is the limestone pea gravel that the petitioner is requesting to maintain. And then as we move up the driveway, you'll see the fence. This portion of the fence is where it's 1 foot from the property line, and then moving through to the back of the site, you can see where the fence continues and the pea gravel exists. And the next few photos show the rear of the site. And then there's another portion of driveway that connects the garage to the primary structure. That's this limestone area here. And this is where it connects to the paved driveway for the primary structure for the residents. And then the last photo shows the fence along the rear property line. And this is the portion where the fence gets to be its tallest. So then for some context, I wanted to remind the board, and Angelia may recall this, that this property did was party, to a request back in 2019 when the detached garage was originally proposed. So there were two requests in 2019. The first was 4819. The petitioner was requesting to build a 40-foot by 70-foot detached garage, which, per our interpretation of the zoning ordinance, would need a variance as it would no longer be considered subordinate and accessory to the primary structure. At that time, the petitioner was also requesting to use a gravel material in lieu of a paved drive. The board did deny those requests, the size of that size of the structure and the gravel drive. The petitioner came back with BZA 6819, where they reduced the size of the building to 34 by 62 feet. And then they no longer were requesting to use a gravel drive. So on the plan seen here, this is the plan that was provided with the application in 2019, showing the new barn, the detached garage, and then a chip and seal driveway, which is an approved alternative dust-proof method, the chip and seal. And that brings us to the request today. So as I mentioned, there are two requests, and I'm going to sort of split them up. The first is the fence. So you can see the fence along the eastern property line and the northern property line. In the NU non-urban district, there's a side and a rear yard setback of 20 feet, and the petitioner is requesting one foot along the side and 4 foot along the rear. The second request, oh, go ahead.
Sorry, Mel, just real quick on that. So is it my understanding from the staff report that if the fence were 6 feet tall, it would be allowed on the property line? Is that correct? It's the
Right,
fact that it's over 6 feet.
Right. Once a structure exceeds 6 feet in height, when you reach that height, you're considered a structure, and that's when you have to meet the structure setbacks. Correct.
Thank you.
So the second request is to maintain the gravel surface, the limestone pea gravel. It's about a 3/8 inch limestone gravel on site to maintain that surface in lieu of either paving the drive or using one of the county's alternate dustproof methods. So here is the regulation from the zoning ordinance that in all zoning districts, driveways have to be paved with a pervious or impervious pavement, except in the floodplain, the park and scenic, the non-urban, the Karst Preservation District, and the R1 Residence District, you can use an alternate dust proofing method. And the county has a list of materials, the chip and seal, the trap rock, other materials that don't kick up dust when they're driven over or disturbed. So the staff, we are recommending approval of the requested fence. There are many portions of the fence where it does not exceed 6 feet in height, where it's even less than 6 feet. So those portions don't need a variance. Along the eastern property line, the side yard shared with a neighbor's side yard, the fence is 6 foot 10 inches at its tallest, where it abuts that neighbor's property line. I would note that most of these residential tracts in this area are at least 3 acres in size, so there is space between the structures. Most of them are sort of central. Additionally, we find that the petitioner has demonstrated a unique hardship on the site. There are some topographical issues and a creek nearby that have created some runoff constraints, and so allowing the fence to be a little bit taller leaves room at the bottom for the stormwater to flow through. We would note, however, that even if the board grants the variance for the fence, the petitioner is still going to have to work with the Department of Transportation and Public Works to mitigate any land disturbance issues that resulted from laying this material and building the fence without a land disturbance permit. So we find that they've demonstrated a hardship to have this fence, but there may be other things they have to address even if the board grants this portion of the variance. So we are recommending approval of the fence. We are recommending denial of maintaining the limestone pea gravel on site. We don't find that the petitioner has demonstrated a hardship to use this material. There are, as I mentioned, there's a list of dustproof materials and treatments you can do to these surfaces to make them dustproof, such as sealing them. And the purpose behind this regulation is to mitigate that dust and debris that comes from that gravel. And this is the limestone specifically is one of the material types that sort of it's the reason we have the regulation is for the dusty gravel types like limestone. So for those reasons, we are recommending denial. I would advise the board that if you think that the limestone gravel is suitable and you approve the variance, that would accomplish their request. But if the board finds that it would be appropriate for this material to be sealed, I would recommend denying the variance, because if they seal the material, then they are meeting the requirement of the zoning ordinance. So sealing it as a condition would actually mean that they don't need the variance at all. So I just wanted to make that clear to the board, that doing a treatment on top of this material, they wouldn't need the variance anyway. They would just then be meeting the the requirement of the zoning ordinance. So I'm happy to answer any questions now, but then we'll also have the petitioner give their formal request.
Thanks for that, Mel. I don't have any questions.
I don't need this. Very clear. Thank you.
All right, I will unmute the petitioner. Okay, Mark, you are a panelist, so you'll be able to unmute yourself and give your presentation.
Can you hear me now?
Yes.
All right. Thank you for doing that. Thank you, board, for listening to us. I'm Mark Rash. This is Laura Rash. I think before you is the site plan with explanation that Mel did on everything, and I think she probably did a better job than how I can explain it. But there are a couple of things that I do want to bring up. So on the site plan, as Mel mentioned, I gave in detail, this is a little complicated because I was clearly trying to explain The fence is higher in some areas than 6 feet, all the way up to 8'4" at the top of our highest post, on down to about 5'2" or 5'4" at the lowest section. My hardship on the fence is, if it's not real obvious, all of this blue area is the stormwater for the neighborhood. Everything that drains in that very flat area, if you're familiar with the valley down there, it all has to run between our two houses. And we ran the fence along the top edge of that, knowing, if you saw the floodplain map, much of this rear area is in floodplain. Just to be clear, Melissa, we did not do any grading or changing of grade in this area or anything. We constructed a fence, and we did dig some pier holes to construct the fence, but not changed any grade there whatsoever. I think she did a pretty good job explaining that this black area is the existing chip and seal that does meet trap rock or chip and seal rock. That does meet the code. In the yellow here is the area that does not meet the code. It was my understanding, and that as long as we had 100 feet coming off of the street, that was either concrete or that is either trap rock or chip and seal, we would be okay for creating the dust to neighbors or out to the street. And that was why we had rocked in around these yellow areas with the limestone pea gravel. Debbie was on site. I think she got to see just how nice the limestone pea gravel is. It's not like 1 inch rock or minus. That does create a lot of dust, and I admit that. However,
create dust.
the 1 inch limestone is more dusty than the 3/8. But the thing I wanted to mention is, on our final inspection back in, I believe it was September 2020, and I walked this entire property with that inspector, including these areas, and he said we are all good on everything. So this has really been a surprise to us that came up. Granted, the fence issue came up, and we're trying to get the appropriate channel for a variance for this, but the gravel kind of surprised us out of left field when, someone approved it 3 years ago, and now county said unless we get a variance, they want us to take it all out. Do I have the opportunity to show any pictures around the neighborhood, or do you guys have those that I sent?
We did put in that sort of grid, the grids of photos that you submitted. But if you want to share your screen, we can make you can do that.
Okay. So that right there, if you'll keep that still, that's a great photo that shows that. Do you see the pink little signs here? I think there's 5 of them.
Mhm.
Do y'all see those?
Yeah.
Okay. Out of the 25 or so neighbors, these are the ones that have a concrete drive. Everything else has either been grandfathered or somehow has white limestone gravel. The back road here, it's called Apple Tree. That is an entire long road of limestone gravel. Over here on to the left of that is the MSD plant. With this picture, I'm just simply trying to show you guys this is a very rural feeling area if you have not been to my neighborhood before. And the reason why we love it there. If you can go on to some of the next pictures, I can just briefly. So the fence, as you can see, it's raised up pretty high in some of these small pictures. Do you see them? But that is to allow the water to flow from that major drainage swale to get underneath the fence, and my reason for height. The White House is our house. That's obviously the subject house. You can kind of look at some of the other pictures and get an idea of some of the rural feel that we have in our neighborhood. Do you have any other pictures on there? Is it Melissa that's controlling this?
I think those are the only pictures we added,
Yes.
besides the few that I went through at the beginning.
Talk about our letters from our neighbors.
Yes, there is also obtained letters from the neighbor across the street, the neighbor to the left of us, the neighbor to the right of us, and they should be included in your package, who are okay with the, actually love the fence, and they think it's a very unique custom designed fence, and are certainly okay with the pea-sized limestone. Would you folks like to see any of the neighborhood pictures to get an idea of the area that we're talking about? And how far apart all of these houses are from each other?
I think the aerial, just the picture that we saw with the aerials, I kind of got an understanding of that, but I don't know about Angela yet.
Yeah, I agree.
So can you go ahead back to the site plan that we presented? As the fence goes down to 1 feet on one side, it actually, if you go to the far left of that red line, it's 15 feet off of the property line. And the reason being is I had to follow the curvature of the swale, this hill that drops down into that floodplain area. And that's why it varies from 1 feet to 3 feet. On one side, most of the drainage area is on the neighbor's property. And on the opposite side, most of the drainage area is on my property. So it did not make sense to follow that distance off of the property line the whole way.
Any questions?
Any questions I can answer for you guys?
I don't have any.
I don't think I have any right now.
Thank you. Is there anyone here in favor or opposition?
I see one hand. All right. Bob, you should be able to unmute yourself.
Can you hear us?
Yes.
Yes.
Camera or no camera?
You should be able to turn on your camera. There we go.
Hello. How are you?
Okay.
Good.
Thanks for hearing us today. My name is Bob Manise. I represent Endress Horticulture Services Incorporated, which is a adjacent and abutting property owner to the Raish property that's under consideration today. Seated to my side also is Dave Endress, who is the president and owner of the corporation, who may have a few words to say after I speak. I presume that the members of the board received our comment letter that was submitted last Friday to Ms. Nesbitt.
We got
That's correct.
several.
I just want to make sure that that letter is entered into the record for purposes of conducting the hearing today and any judicial review that may occur.
What does the letter say? I would like to see it. Can you hear us?
I can hear you. Was the letter just on the screen?
The letter that we have in the presentation is from the property owner.
Okay. Oh, okay.
I would like my comment letter admitted into evidence for this hearing.
That should be in the presentation. I'm quite sure.
I took the comment letters out because they're in the file. So if you've submitted your letter to Debbie Nesbitt, then it will be in the file.
Okay,
Mhm.
thank you for that clarification.
I heard
the-
Debbie speaking through the wall, but she, I think, was still muted.
I'm looking at your letter now.
I do have the letter in the file.
Thank you. So there's two main points that the letter puts forth regarding whether you should decide to grant a variance related to the height that's required in the NU district. I think I'll start with the second point in the letter. Section 1004090 says that the board may not be deemed to authorize the board to validate, ratify, or legalize any violation of law or any regulations of St. Louis County zoning code. With the letter, we submitted an exhibit 1, which is an information filed by St. Louis County against the Rashes for building a fence that is too high. The Rashes went ahead and built a fence within the setback that exceeds the limit, and they have a pending prosecution going on over this fence. And section 1004090 basically prohibits the board from issuing a variance to legalize the illegal conduct, the alleged illegal conduct. So unless and until that prosecution is resolved and deemed to not be illegal, we believe it is improper for the board to grant a variance related to height. The second reason why the board should not grant a variance related to the height of the fence is because there are no practical difficulties here. You call them hardships. When we talk about an area variance, we look at practical difficulties. It's a little less stringent than unnecessary hardship. And what the Missouri Supreme Court has said for a non-use or area variance is that an applicant has to demonstrate that they cannot use their property for a permitted use without coming into conflict with the area regulations. And here, there's just no way for practical difficulties to be demonstrated. In the last presentation on the variance you granted, there were reasons related to the shallow, angular configuration of the property. Here we have a perfectly rectangular property. I respectfully disagree with the staff's conclusion that there are topographical limitations on the site. The site is in a floodplain. It's relatively flat. There's no reason why the applicant can't use his or her property for a residential use without coming into conflict with these requirements. And so, you know, there's a good example from 1968 where the Missouri Supreme Court said, yeah, it'd be good to grant an area variance to allow a telephone company to have a higher building because they need it for the telephone poles. They're permitted to use the property in a way to operate a telephone business, and they can't operate the telephone business appropriately without having some variances to the height limitations. In 2018, the Supreme Court of Missouri looked at this concept again. There was a church that wanted some variances to a sign code. They wanted a digital sign, and they weren't allowed to have a digital sign. And the Supreme Court said, you know, they've been using the church for church purposes, and they can't show any practical difficulty in not complying with the sign code. The fact that they didn't look into the regulations about what they could or couldn't do with the signs doesn't amount to a practical difficulty or a hardship, and to allow this digital sign would just be mere convenience for the property owner. That's exactly the case that's going on here. The Rashes did not look into the appropriate zoning regulations. They want this fence to be higher for mere convenience. There's no practical difficulty. In fact, they had been using their property for residential purposes before they built the fence, and they will continue to be able to use their property for residential purposes without having an 8-foot, 4-foot fence that is significantly exceeding the area requirements for the NU district for fence heights. And now I would turn it over to Mr. Enders.
I have, as you've seen on some of the letters from the neighbors and stating how beautiful the fence is. And granted, it is a very pretty fence on the Rashes side of the fence. But if you would look at the outside, where typically building fences, it's not a code. We can't put our hands on it, but the pickets would go on the inside. This fence was built with the pickets, the pretty side on the inside, or the pretty side of the fence is on the inside. The pickets are on the outside of the fence. I did submit some photographs showing what this fence looks like. It is Exhibit 2 dash P2 is one, dash 1 is one. The neighbor who looks at this from the north side, which Mark and Lard did not get a letter from to approve of it, he has to allow invasive honeysuckle to grow on his property line so that he doesn't have to look at it. I've been asking Dave for years to get rid of the honeysuckle, just in fact that it is invasive and that the seeds are spread all over the valley down there, and we don't need any more honeysuckle. But I see Dave's point. He doesn't want to look at the fence. It essentially looks like a fence that you would see around a junkyard on I-44 when they made all the junkyards confine their appearance to the interstate. Any questions about that?
Yeah, I have a question of staff. Is any of that last part relevant to the variances necessary?
Regarding the like
The
fence
basic-
orientation?
Yeah, exactly.
No, I don't think so.
Okay, I'll agree to that.
Yeah,
As long-
not that I don't understand your plight there. I do, I get it, but I just don't know that there's anything we can do as a board on that regard.
And I think what our position is that you don't have to grant variances to the simplest solution is to make the sections of the fence that exceed 6 feet, and that there's no reason why the fence can't be made to be 6 feet tall. Then you don't need a height variance and you don't need setback variances.
Okay, thank you.
We have one other hand raised, so I'm gonna mute the previous speaker. And okay, Jamie, you should be able to unmute yourself now.
Hi, can you hear me all?
Yes.
Oh, good afternoon. My name's Jamie Mansfield, and I'm an attorney with Armstrong Teasdale, and I have been assisting the Rashes along the way, and also with respect to what I think Bob, I don't know if he mentioned if he was an attorney or not. I haven't seen his letter that he prepared, but he had mentioned before about the zoning violation, which brought this all to a head, but nothing that you are doing here today with respect to what staff and their good measure have come out there and sought recommendation and have listed a recommendation for the fence about the hardship that exists on the fence. Those facts are before you in any event, but also too, nothing of what you decides here today automatically erases the court case. We still have to work with Ms. Shaw in the prosecutor's office. What it does is set from this day forward, right, that the variance is granted, and then from this point forward that the fence is in conformity with the existing site plan as granted by this variance with respect to the height. We would go back to Ms. Shaw, and that's between Ms. Shaw and on behalf of St. Louis County on how she wants to prosecute, however many, days that we were in violation. I'm sure there's some measure for that as well. With respect to this, or if we were in violation, that is her decision to make. It's not necessarily that you guys are saying automatically from beginning the point of time, that we all of a sudden were not in conformity with the law. It's that this decision that you're making here today establishes point zero. This is the date. So that's what I wanted to make clear to here today with respect to the court case, which is separate and apart from the determination that you guys are making here today. I will let my client, although I'm not sure about the procedure here, but if there's any response, but I think Ms. Wilson laid out great recommendations. She's been out to the site. Her history and background as a senior planner there in St. Louis County carries a lot of weight. I'll just leave it at that. Thank you very much for your time.
Thank you. Justin, do you have any other questions for the petitioner?
I don't think I do right now.
Okay, I do have one. The height variance on the fence, is that because there are valleys and they're just trying to even out the fence across the board? Is that why it's going up to 8 feet in some places?
No, actually, can you hear me okay, by the way?
Yes, I can.
No, it's because we're adjacent to a major drainage swell that drains probably 60 to 80% of our entire neighborhood. And I've seen that swell and it comes up like a raging river. I've waded in that swell. It actually drains the other gentleman, Dave Endry's property to keep water flowing here. And so, we certainly don't want a fence that is below where that water flow is. And so that fence you can see from some of the other pictures is at least a foot and more off of the ground. At the end of the day, I guess I'm trying to figure out what the other gentleman has against the fence. I don't know if I can share a screen, but the fence was not built with any difference on either side. One side is white, one side is black, but they both have the same 2x6 posts exposed on both sides. There's again no difference at all. In fact, the actual post, even though they're on the outside, we put matching post on the inside, half post, just so it is obviously looking like both sides besides the color. I think the other gentleman probably has some other motives here. Not going to speculate on that, but not sure why he doesn't like our fence when you compare our property and things like that to how some of the other properties are kept,
To his property.
namely Dave Endry's. I don't get it.
Okay. Thank you. I believe we're ready to vote.
Okay, yes, I don't see any other hands raised. So at this time, I will mute the petitioner so the board can take their vote.
Jonathan, don't mean to put you on the spot, but do you have any thoughts on what we've heard from two different attorneys on this particular case regarding the height variance?
What I would suggest in this situation is, if you're looking for legal advice, we'll have to notice up a closed session for a meeting in the future, and then go into that closed session to discuss these issues.
Well, yeah, I just, we're hearing two totally different opinions on the variance, and in my understanding of it, I have an opinion as well, but yeah. Yeah, that's my only question I've got right now.
Okay. Are you ready to vote, call for the motion?
I move that we continue this to get legal opinions based on what we heard in the testimony today from the St. Louis County Counselor's Office.
Okay, I second it. All those in favor? Aye.
Aye. Do we,
Okay, it's continued.
John or Mel or whoever, do we just continue it? Do we have to continue it to a specific date, or is that just continued until we?
To the next meeting.
Typically, we just add them on to the next meeting. We'll work with Jonathan to make sure that he has time to prepare any additional information he has to give to you, but I would expect we'd try to do it in 2 weeks.
Okay.
But we will work on facilitating that offline here.
Awesome. Thank you, Mel.
Sounds good. The motion is continued.
And that was the last agenda item today.
Okay, so I move to close the meeting.
I'll second that.
All those in favor? Aye.
Aye.
It carries. Thank you.
Thanks, everyone.
All right.